All right, thank you, everyone. I do not have an assigned clerk this morning, secondary to some of this pandemic stuff and some of the restrictions and requirements and so on and so forth. We'll get right at your matters. We started a little bit behind. We'll get right at it. All right, first call is case number 21-165-707. This is Jacqueline Spearman versus Across the Park Apartments. Matter set on today's date for a hearing. Looks like this is the first hearing. It looks like this was sent to the Wayne County Dispute Resolution Committee. Your appearance for the if I have an appearance or Ms. Spearman, attorney for Ms. Spearman, or Ms. Spearman, I'm just going to say something at this time.
Yes. Good morning, Your Honor. I am here. Ms. Spearman is here today.
Good morning, Ms. Spearman. For the defendant Across the Park Apartments, your appearance at this time, please.
Good morning, Your Honor, and to you and your staff. Brian Butchart, P66250 for the defendant.
All right, thank you, Mr. Butchart. Good morning to you, Mr. Officer. I do see that where this started with the complaint of the defendant in this matter arising out of a landlord-tenant matter, that there is now also a counterclaim raised in this matter as well. I did issue a provision for this to go to an alternative dispute resolution. Did that in fact occur, Mr. Butcher?
It did, yes.
All right, and any degree of success whatsoever, sir?
A resounding no. No degree of success whatsoever, Judge.
All right, very well. And that's about the size of things at this point, Ms. Spearman. Is that correct, ma'am?
That is accurate, Your Honor.
All right. So what I'm going to do is I will set a schedule on this matter so that the parties can exchange information and it looks like to me that I'm just looking through something here. All right, so I will set a period for the parties to engage in discovery. There is a counter complaint in this matter. Ms. Spearman, have you responded, filed a written response to the counter complaint at this point?
I have not, Your Honor, as this matter originated in an eviction court with Your Honor Ruth Garrett. At that time, there was no opportunity to present any evidence, or these are just
you're going beyond the scope of the question that I asked you. This case is, of course, and I do have that history. This case, of course, is in front of me, and there's been a counterclaim that's been filed against you. It's important that you respond to the counter complaint in this matter. That it looks like it was filed with the court on somewhere around somewhere in October 2021. So that means that you're suing them and they're suing you as well. So it's important that you file a written response to the lawsuit that they filed against you, so that the matter is properly brought before the court. Otherwise, what happens is that you end up getting defaulted on that counterclaim. So you got to file a response to that.
I will do so immediately, Your Honor.
Thank you. Very well. So I'm going to set this on a 60-day discovery under the court rules. The parties may engage in discovery back and forth, may request information that they believe would help in assist in resolving this case, and assist in trying the case. If there's any information under the control of the other side that you wish to have, all you need to do is put something in writing and request that information. You're required to turn that information over so long as it is relevant to this case. Additionally, if there are documents sent out, such as a request to admit certain items, that has to be responded to. If there are what's called interrogatories, a set of questions that are sent out, those questions have to be answered. All of those kind of requests for reductions, anything along those lines must be taken care of during the next 60-day period. I'm going to set a pretrial conference after that 60 days. Upon setting the pretrial conference, I'm also making that a motion hearing date. That means that if either party wish to file a motion in front of this court and wish for it to be heard on the date that I'm going to give you, you will have to file your motion soon enough to give the other side at least 7 days to respond to motion. As long as you file your motion, whether it's dispositive, meaning a motion that could end the case, or a motion that is non-dispositive, meaning a motion that addresses some issue in the case. You file your motion and set it for hearing on the date that I'm going to give you. All you need to do is give the other side at least 7 days to respond prior to the hearing date. So the next date that I'm going to give you is going to be in the month of March. I'm giving you March 28th. That's going to be at 9:30 a.m. You will get a scheduling order from me in the mail. The information that I just gave to you, that information will be reduced to a written order. You will get it from the court in the mail. And I will see you at the next hearing on the 28th of March at 9:30 a.m. I wish both sides well prepared to you.
Thank you, Honor. We miss you. We miss you up in landlord-tenant land. I'm sure you don't miss it up there very much, but we miss you.
I always love the people and the issues over there. But here is kind of number one. That's number two. So so it's good to be here.
Take care.
Thank you, Your Honor.
And then I told, okay, if you need me, just call me, and I told Karen, do you want them brought, where you want them brought to? And where you want them sent? Okay, I'll let you know, because she asked me.
That's my fault. Set up.
I know, the files on the second floor.
Anytime.
Yes, Carrie's gonna take them up today and bring them, but she asked me, she said, "Where's the file set?" I said, "I'm back on the list."
And
Okay,
these are all done.
okay, I can, yeah, we so short, I'm working in the courtroom. I do. A sale and courtroom phone number, so I'm gonna paper.
Gotcha. I appreciate it.
All right, thank you.
All right, court case case number 21-166-312. This is Dearborn Pain Specialist versus City of Detroit. The matter is before the court. Looks like I set it over for a motion hearing on today's date. Your appearance at this time for the plaintiff, please.
Good morning, Your Honor. Gary Blumberg on behalf of the plaintiff.
Carol Ronk on behalf of City of Detroit. Just quickly, it looks like there may have been difficulty.
Plaintiff counsel, your P number, if you will.
I'm sorry, Your Honor. I hate to repeat it. I think I've told you before. P2820.
I'm 54897.
All right, well, it brings well to my ear, so this is my first time hearing it.
There you go.
All right, so Ms. Rourke, go ahead, ma'am.
It looks like we may not, I mean, I don't know how the e-filing system works in 36th District Court. My secretary seems to believe that by e-filing the motion, it served it on plaintiff's attorney, and I don't think that in fact it did. So I don't think the plaintiff had a chance to respond to the motion.
Your Honor, that would be correct. I didn't know about it until this morning when I had emailed Ms. Ronk on it. It's the first, she did email me a copy, but I'd like an opportunity to respond.
All right, well, I have received a copy of the motion, and given the parties that are so well learned and so sophisticated that they need not even state their P numbers anymore, I suspect that they could deal with this motion without filing anything. But given the fact that
You know, Your Honor, you might be correct. As I glanced and scanned the motion, I didn't digest it all. If Ms. Ronk is right, I may not be responding to it, and if she's wrong, we'll talk further on it.
all right, very well. Well, right and wrong are the big issues of the day. Okay, so why don't we set this over for a couple of weeks that you do it. Maybe I'm thinking, given that we're at the 20th now, I'm thinking maybe the 3rd of February, the latest would be the 10th.
The third. The third.
So how is it? How is the 3rd looking for everybody, or the week of the 7th?
I'd rather the week, well, it's not a terrible day. So if I can digest that to somebody else, why don't we, the 3rd is fine, Your Honor. I'll do the 3rd.
I'll have to be at a Wayne County hearing at 11. So if we could do it, so we get out of here 11, that's fine.
All right. I better put you at another time then, because I don't have the benefit of my clerk to tell me that you're doing something crazy on the 3rd. I know that week is busy, so let me just go ahead and move it over. Let me just go ahead and move it over to the 8th. That works for everybody. 2/8/21.
That's good for me.
Hold on one second, Your Honor.
All right, and the docket is not as crowded that day, so I'll be able to get you in and out of here fast at that time. So I'm adjourning the motion hearing, finding good cause for the same, and adjourning over to that particular day. You'll get an order in that regard as well.
Will that be at 10, Your Honor?
9:45 a.m. on the.
9:45.
Thank you. Good day to the two of you.
Thank you.
9:45 to 8. Got it.
So that's it for the day.
Gotcha. Thank you. All right, court.
All right, talk to you later.
Thank you, Your Honor.
Thank you. Good day to the two of you.
You too.
All right, the court now is looking to 21-163-521. This is Community Financial Credit Union versus Megan Wigley. The matter is before the court on the filing of a general civil complaint. Do have a responsive pleading and answer as to file. This is the first hearing regarding this matter. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. John Mueller appearing on behalf of the plaintiff.
And good morning to you, Mr. Mueller, and I will need you to put your P number on the record if you will.
I'm sorry, Your Honor. You asked for,
Your P number, for, if you will, for the record, sir.
oh, I'm sorry, P35413.
All right, thank you. And again, good morning to you. I'm looking now for Megan Wigley. Ms. Wigley, if you're on the Zoom, please say something, or your attorney, please say something at this time.
Yes, Your Honor, I'm here today.
All
Megan
thank
Wigley.
you, and good morning to you, ma'am.
Good morning.
This it looks like this is a complaint that arises out of alleged indebtedness regarding Community Financial Credit Union. And I looked at the answer in this matter, and it basically says it doesn't agree with the allegations that were made, and then it alleges that the contract is unjust. Has there been any opportunity to talk about perhaps finding a way to resolve this matter? I do see that there is a claim of total damages in the nature of $17,767. Looks like this started out somewhere along the line at about $12,000. But it looked like there was a contractual interest rate in excess of 10%. And so that would escalate that number. In fact, this looks like the purchase of a vehicle or some item that started out at $16,181. And there's a claim of default on this particular loan. Okay, so what I'm getting at here is that there may be some room for the parties to kind of talk about this and find out if some of that interest can be abated, if a payment plan can be reached, that the parties can stipulate. If it ultimately is heard by the court, or a motion is filed by the court, then whatever the numbers are at that time would be what the court would have to do with the judgment on. That's why sometimes it's better for the parties to try to talk about it, see if you can come up with a number that works. And also, as a part of that, coming up with perhaps a monthly payment that might resolve the matter. Ms. Wigley, does that make sense to you to try to talk about it that way, man?
Yes, Your Honor. And I did talk to Mr. Mueller last month, and he did require just some expenses that I discussed with him. And I emailed those documents along with proof and a tracking of the items that I had. And I ended up asking him for a proposal to settle the claim. And I did provide him that number.
All right, yeah, that's a reasonable way to at least start talking about this case. Mr. Mueller, is it helpful if I put the two of you in a breakout room at this point, or are we not along that grid at this time?
Your Honor, actually, we've been talking for months. Ms. Wigley is correct. In fact, there's been even more communication by email and by phone. And she is alleging that due to her financial condition, she just cannot come to a number that my client would accept, and we're actually pretty far apart.
All right.
So I don't.
To come closer together, I need a client that has a stiff arm, so I can twist it a little bit. I'm being facetious here. I was talking about twisting an arm to get you a little closer. You say you're pretty far apart now. Yeah.
Yes.
Let's see if we can. I'm sorry, Mr. Mueller. You're not hearing me that well, are you?
I actually am now.
Yeah, that's what I figured, because you didn't laugh at my joke, and that kind
Oh.
of.
I didn't hear it.
In any event, I was saying that perhaps if your client was here, maybe I could twist a stiff arm, but I was kidding about that.
Okay.
Anything that the court might be able to do to engage in this matter that might help the parties to come a little bit closer together. And the reason I mention that is because while interest is very, very real, I see that the interest in this matter is pushing its way close to almost 40% of the claim. And if some of that, and I don't know what you were talking about, certainly if some of that could be negotiated, I think you might be able to get to the finish line.
If I might, Your Honor, we're nowhere close to the principal balance even. So I don't think the interest would be the stumbling block, but we're really not even close to the principal balance.
All right. So it looks like the principal in this is in the nature of some $12,000, $12,400 or so. Correct, sir?
That's correct.
So, Miss Wigley, it's a big claim. So if you're going to try to resolve it, you have to do so with some relevance to the claimed amount regarding this matter. And that's unfortunate. Obviously, if the claim was small, it's always easier at times to resolve that. So what I'm going to do, I think that I think that you need to perhaps talk a little bit more on this. And this, Ms. Wigley, it might mean that you've got to come up with a proposal that's a little bit stronger than perhaps what's been put out there. I don't want to know the numbers because I may have to try the case, and so I don't want to know what you're negotiating. So what I'm going to do is I will go ahead. Is there any discovery issue? Are there any discovery issues that are outstanding, counsel? Any information that you need regarding this matter?
No, I had put off discovery because we were discussing this a lot, but I think I'm going to have to serve maybe some requests to admit and posture this for a motion for summary.
All right. And Ms. Wrigley, what all this means is that the next 60 days will give both sides an opportunity to exchange information under a court order. That means that if there are some documents under the control of the plaintiff in this matter that you would like to see, you'd like to see an accounting, how they came up with the numbers, anything along those lines, you can request those documents in writing. Simply put something in writing and request that those documents be turned over to you, and they will be required to give you those documents. They can also send requests for documents to you. They can also send items that are called interrogatories, which is a set of questions asking that you provide answers. They can serve things that are called requests to admit, and that is a document that will request in order that you admit under oath whether something is true or not, you can do the same thing. You can send requests to admit various things, interrogatories, and requests for documents as well over the next 60-day period. And so what I'm going to do is I'm going to set your next hearing in this matter for 3/28/22, and that's going to be at 9:45. I am going to set that date as a motion hearing date as well. That means that if either party wishes to file a motion, dispositive or otherwise, they can file a motion and set it on for hearing on the 28th of March, 2022 at 9:45 a.m. And I would hear the motion on that date. The only requirement is that the other party or that the party filing the motion make sure that the opposing party has at least 7 days to respond to the motion. So I'm going to send out a written order that is going to have that language in it under paragraph number 6. And it will be the scheduling order for this case. It will also have a return date of 3/28/22. Discovery is open through that date. It means that you may request information and obtain information through the 28th of March 2022, and that is the next hearing date for this matter. I do wish both sides well. I hope that you will keep talking and trying to reach a number that might resolve the case. If not, I will put some effort into trying to make that happen the next time around. I will also address any motion that might be filed before the court at that time. I do wish you well, Ms. Wigley. I wish you well, Mr. Mueller. Good day to you.
All right, thank you, Your Honor.
Thank you, Your Honor.
Are you okay? She told me to keep my head in and see.
Yeah, we're trucking along.
Okay.
I'll come back. I gotta go back up.
All right, I appreciate it. Thank you so
All right.
much.
You're welcome.
All right, the court now calls case number. This is case number 21-52185. This is City of Detroit versus Redeemed Christian Fellowship Ministry. The matter is before the court, set on for a non-jury trial on today's date. Your appearance for the City of Detroit in this matter? For Redeemed Christian Fellowship? All right, I'll recall this matter. My pick file for the day. We'll come back to that one. All right, now we come to the stuff that makes life really interesting. Case number 18-162-693. This is Bright Financial Services versus Shamerica LLC. This is an application for judgment against a garnishee defendant. The default of the defendant has already been entered by the court, and there is a request for entry of the judgment. The court set it on for today's date. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Robert Goodman, P55670, on behalf of the plaintiff.
Thank you. A good point to you, Mr. Goodman. Do I have the defendant, Shamerica LLC, on this Zoom at this time?
I don't believe so, Judge.
All right, the court did send notice with regard to this hearing and entered the default upon the request where there was no response. Where the defendant has not appeared, the court will now enter the judgment by default as presented, and the judgment will enter for the total amount of $4,449.41. It is so ordered at this time.
Thank you, Judge. I do have one other matter.
Oh, you're trying to jump the line now. What's the?
I wouldn't normally do it, Judge, but I have an 11 o'clock dentist appointment. If I could do it, I would be much appreciated.
Oh, you could do it from the dental chair. What's the last 3 digits of your case?
362.
Wesley Holdings.
Oh, wow, I'm glad you said something. That's the very last case on the call. This is 21-160-236. This is Midland Credit Management versus Raymond Massenberg. The matter is before the court on an application for default judgment. Counsel has previously entered.
Judge, that's not the right case. It's 17-105-362.
All right. Let's see if we find that one. This one. 17 gauge should jump right on it. I am not seeing your case. Let me look one more time. Madam Clerk is on, Madam Court Reporter, it is on the docket. Do you see it? Yeah, I see it on the docket.
Yeah, it's on the docket, Judge, for 10:15, looks like. Is it Wesley Holdings?
Yes, it is.
Yeah.
One moment, sir. All right, I'm not seeing that I have that file in front of me, but I will call case number 17-105-362. This is Wesley Holdings LLC. Looks like versus Ellis Frost. And the matter set on for a hearing on entry of default judgment. A default was previously entered in this matter on the application of the plaintiff, and the court set the matter for hearing on today's date regarding the request for entry of default judgment. Counsel, while I do have the file on this matter, I do know that there is a request for entry of default judgment. Let me see if I have the defendant here. Is the defendant present on this matter? Ellis Frost.
Yeah, and Judge, it's against the garnishee defendant. Tenet Health Corporation is the garnishee defendant.
All right, thank you. And that, yeah, I see on the next page that comes up as well. Thank you, counsel. I do see that information. Again, the court is working without file. Tenet Health Corporation, anybody on behalf of Tenet Health Corporation? All right. It looks like they've not appeared, although there was a notice that went out regarding this hearing, counsel. So you're on your request, the judgment will be entered now by default. And as I've indicated, I do not have the file at this time, but I'm sure it's around here somewhere in my, you heard me say earlier that I don't have a plug in place. So I will enter the judgment as soon as I get my hands on it. And we'll
Thank you, Judge. I appreciate it. And for the record, the judgment amount should be $1,828.89, which was the amount of the garnishment.
Got it, sir. And the judgment will be entered for that amount as correct.
Thank you, Judge. I appreciate it. Have a good week, rest of the week.
Just one moment. All right, the court is calling case number 21-161-033. This is Jefferson Capital Systems Incorporated, or LLC, versus Derek Light. The matter is before the court on application for entry of default judgment. The default was previously entered on the 13th of December. The matter was set on for a hearing regarding entry of the judgment. Your appearance, counsel.
Kara Bailey, P73071 on behalf of the plaintiff today.
All right, thank you, Ms. Bailey. Thank you for your patience this morning. Do I have Derek Light on the Zoom? If you're anywhere on the Zoom, please say something at this time. It appearing now, the defendant has failed to appear at the hearing, even though a notice was sent out, and the defendant did not otherwise plead as it relates to the underlying case. The court will now enter the judgment by default on the terms as prayed. Total amount of the judgment on entry is $1,039.27. The judgment is entered at this time. Thank you, counsel.
Thank you, Your Honor.
The court now calls case number 21-159-9950. This is Goldman Sachs Bank versus LaShavon Mason. That first name Lashabone, last name is Mason. The matter is before the court on an application for entry of judgment by default. The record should reflect that the default was entered on a previous date, and today is the date for entry of the judgment itself. Your appearance for the plaintiff in this matter.
Sure. Good morning, Your Honor. Attorney Jason Brainer, P69653 on behalf of the plaintiff, Goldman Sachs.
Thank you, counsel. What a great name for an attorney, and then also for Goldman Sachs. Huh?
Sure, why not?
All right. Do I have the other side on this? Mason, anywhere on this Zoom? If you on this Zoom, please say something at this time. The court did send out a notice regarding the application for entry of default. Defendant has not appeared and not otherwise responded to the underlying case in this matter. And therefore, the court will enter the judgment now by default. The amount upon entry is $10,930.13. And it is the judgment is entered at this time. So thank you, counsel. Good day to you, sir.
All right, thank you. Same to you, Your Honor. Appreciate it.
The court now calls case number 21-16649. This is Rock Creek Capital LLC versus Akila Amos. The matter is before the court on the application for entry of judgment by default. The court previously entered the default of the defendant on the 13th of December 2022. And the matter was sent out as a notice for entry on today's date as to whether or not there was any reason why the judgment should not be entered in this matter. Your appearance for the plaintiff at this time.
Scott Mancinelli for the plaintiff, Rock Creek Capital, P60148. Ms. Amos is here too. She needs to unmute.
All right, thank you. Thank you, counsel. Let me see, Akila Amos, say something. It looks like you're there. Say something if you're there. Please say something at this time. You can hit *6 if you're on mute. Hit *6, it'll allow you to speak. Yeah, you're still on mute, if you will. Hit *6 to get you off of mute, ma'am. I see you there, but I can't hear you. If you have a microphone signal on your device, then tap that and it'll take you off mute. Or you can hit *6 and that should get you off mute. All right.
We did exchange some chats regarding settlement and payment plans and things like that while we were waiting.
Oh, you had an opportunity to talk about it?
We did quite a few messages going back and forth, and it sounds like she might be willing to do a payment plan for installments.
All right, very well. Now, I'm sorry I missed your communication with the court. You wanted a breakout room. Yeah, you want to try the breakout room and see if that works at this point. I know you've had your discussions.
I do, but I'd like to see her find a way to unmute herself first.
Yeah, that's the biggie right here, right there. And Councilman Midland, I'll be right with you, sir. Mr. Keeley, you still working at it, ma'am? All right. Did you? Yeah, you make it. Your lips are moving, but I don't read those. I don't read that well. The lips that well. Did you try the *6? You try *6 to get you off.
She could call my office line and I could put her on speaker.
Yeah. Okay. Okay. So Mr. Mancinelli is going to give you his office number, or if you have it on some form, you can call right now, and we can hotwire you in that way as well, Ms. Amos. So are you ready to take that number, or do you already have it?
616-930-4509. 616-930-4509.
All right, she's got it. All right, so when she calls in, I'll come right back to you, sir. So you can go ahead and handle that, okay? All right, this is case number 21-162-837. This is Midland Credit Management versus Catherine Kennedy, that's Gatherin,
Good morning.
for appearance at this time, council.
Morning, Your Honor. William Hill, P 28608, appearing on behalf of plaintiff Midland Credit.
Thank you, council. It looks like you may be here on 21-161-532 regarding Midland versus Alita Moore.
Yes, sir. I have 4 of them set at 5 minutes apart.
It looks like you may be here on 21-161-200 Midland
Yes.
Credit Angel Ballard. Looks like you might be here on 21-160-236 Midland Credit Management versus Raymond Massenberg. Is that correct? Your appearances on each of these matters, is that correct, counsel?
Yes, Your Honor. I'm appearing on behalf on all 4 of those cases for plaintiff.
All right, thank you, counsel. And counsel, let me just make a check right quick. Do I have Gatherin Kennedy on the Zoom? If you're on the Zoom anywhere, Ms. Kennedy, say something at this time. I'm also looking for Stephanie Strickland. I'm also looking for Alita Moore, living on Lakeview Street in the city of Detroit. If you're anywhere on this Zoom, please say something at this time. I'm also looking for Angel Ballard, living on Prairie Street from the city of Detroit. If you're on this Zoom at this time, please say something. I am looking for Raymond Massenberg, living on North Lawn Street, the city of Detroit. If you are anywhere on this Zoom, please say something at this time. Council, each of these matters have been noticed for hearing on today are regarding an application for entry of default judgment in each matter. The defendant did not respond regarding these matters itself, but on application, the court did set up an opportunity for defendants to come in to indicate whether or not they believe this judgment should be entered. Neither of them have appeared. They are not a collection, but I call these cases individually, and neither of them have appeared individually. Accordingly, with regard to the suffix 837, the court will enter the judgment on the application of the plaintiff in the total amount of $1,260.06. Defendant having failed to appear for this hearing and having failed to plead or otherwise defend with respect to the underlying case. The court also at this time looking at the suffix 532. The court has called for Alita Moore. Defendant has responded, not here, did not respond regarding the underlying case. Accordingly, the court will enter the judgment by default at this time on the application of the plaintiff, finding that there is due to the plaintiff the total sum of $1,320.28. The judgment will enter now as phrased. The court is also addressing now the suffix 200 Midland versus Angel Ballard. The court has called for Ms. Ballard regarding the property, regarding a person by that name living on Prairie Street. Ms. Ballard has not responded, did not plead in the underlying case. Accordingly, the court will enter the judgment now by default on the terms as prayed. The judgment will enter for the total sum of $2,919.42. It is so ordered at this time. The court has also called the suffix 236 regarding Raymond Massenberg. The defendant did not appear, has not responded to the court call. The defendant did not respond to. The defendant did not respond to the underlying claim.
All right. We're just waiting right now for our turn.
As well. Accordingly, the court will grant the application for entry of default judgment at this time. The judgment will enter for the total sum of $6,545.63. It is so ordered at this time. Those judgments are in the council.
Thank you, Your Honor.
They'll get those right out to you, sir.
Okay, thank you.
All right, and we're back regarding subject 649. Thank counsel for your assistance. It sounds Ms. Amos is somewhere there in the background. Good morning to you, Ms. Amos.
Can you hear her, Ms. Amos? Hear the judge, Ms. Amos?
Yes,
Okay.
yes.
So I have, this is Scott Mancinelli, attorney for Rock Creek. I have Ms. Amos on my office landline on speaker, and we have worked out a consent judgment for 7,000 even. There's a proposed judgment at the end of the motion I filed, Your Honor, that maybe you could just cross out and use. So I'm giving her a little discount from 7,429 to 7,000. And
Let me stop you for a moment, because the application for judgment that I received has a total judgment amount of $6,047.96.
and then I filed a motion for entry of default judgment with a different amount, with included attorney fees.
I do not have that. I have the application for entry of default. And the application that I have, it has the amounts that I've set forth.
All right, well, taking the path of least resistance, then we'll take that. And she's agreed to pay $100 a month for the first 12 months. And on month 13, increasing to $175 a month with the first payment on February 5, and then the 5th day of each month thereafter. Is that correct, Ms. Amos?
Yes, that's correct.
All right, so the judgment will enter as prayed. It will be treated as a consent, and the judgment will be paid over time, with $100 being paid on the 5th of February 2022. That will continue until the 5th of February 2023, at which time the payment increases to $175 and continues to $175 and continues until the balance of the judgment is paid in full. Is that a full and accurate recitation of what the agreement is between the parties?
It is for me. Is that correct, Ms. Amos?
Yes, that's correct.
Okay. And that the judgment you have there will work for you to add those terms, Your Honor?
Yes, sir. Yes, sir.
Okay.
I'll either use this, or I'll work at some other modification. I should be able to get it out.
All right. So we'll just wait for you to send that back. Thank you very much, Your Honor.
Thank you. Thank you. And
We're
good
off
day
the
to you.
record. Okay.
Good day.
Ms. Amos, hold on for 1 second.
Mhm.
You need a breakout room, sir? Deborah, you good out there?
Yep, I'm good, Judge. So what happened to the trial?
I don't know. I'm gonna call them again. We'll wait until